We do not have anyone to introduce us. So Hilda and I are just going to say what we like about ourselves. And Hilda's going to start.
Good morning, everybody.
Closer?
My name is Hilda Dupree, and I'm a notary public with a practice in Vancouver West Side. And I mainly focus on personal planning and estate planning. And so I'm very excited to be here. Closer?
Much closer.
Yeah.
Even more close.
It's like Siri on my iPhone. Nobody understands me. So my name is Hilda Dupree. I'm a notary public. I have a practice on Vancouver West Side, and my practice focuses mainly on personal planning and estate planning. And I'm very, very excited to be here, and I hope we'll be able to have a good discussion.
My name's Martha Jane Lewis. I'm Executive Director and practicing lawyer with the BC Centre for Elder Advocacy and Support. Our focus is on educating the public about the way we are treated as seniors, or the way we treat seniors, basically around finances and medical issues. We also have a legal clinic and a legal advocate. Half of her work is helping people get government benefits that they're entitled to. And then we do a bunch of workshops. The reason we're talking about this is that as everybody ages, there may be diminishment in their mental capabilities around certain parts of their lives. Recent court decision, the Wolfman's Stoddard one, found that generally the first thing to go is the ability to handle money or things to do with numbers. And then about halfway down the continuum, you get the ability to make decisions about getting married and divorced. And then last things to go are usually decisions about where you want to live and medical treatments. Ageism exists, and older adults can be treated as children, often with the best of intentions. They're adult kids thinking they're protecting their parents by second-guessing the older adults' decisions, thinking they know best. It's a bit of role reversal from when we're children. And older adults can become very dependent on people who may end up taking advantage of them, intentionally or not. It can be because of physical frailties or mental frailties, and loss of a spouse, loss of their friends, loss of a social circle. So they become terrified that if they're not in good with their kids, they may have nobody in their lives. So what we're talking about today are some of the things that can go wrong when people are trying to plan for their later years.
So one of the things that I, like many legal professionals who focus on personal and estate planning, are confronted with, I would say, on a day-to-day basis, is clients coming in with the request that they want to make a change to the title of the property, the family property. They either want to add a child or children to the ownership, or they want to transfer the ownership to a child. When the client comes in, they usually come in with a very strong opinion that this is what they're going to do. And they usually are not anticipating that a discussion will take place about this, which is, of course, what is to happen, right? The main reason why people are motivated to do this, I would say, is threefold from what I can see in my practice. One reason is from estate planning perspective. People want to avoid probate. The second most common reason is from a personal planning point of view. People are in need of being taken care of, or foresee that care will be a need in the future, and they want to make an arrangement with the person who will provide the care. And the home ownership is part of that. And the third one, which we see increasingly, is because of qualifying for a loan or a mortgage with a financial institution. And financial institutions are less interested in an individual once they are on fixed income, regardless of what their investments or equity is. A bank will focus on cash flow. So zooming in a little bit on each one of those three, the first one, which is the big one, the probate. I have come to conclude from doing what I do on a day-to-day basis that clients and people are afraid of taxes and are going to do anything they think to avoid that. And the second big thing that motivates people is they are afraid of suffering. And those two things are usually a big drive why people go and do take the effort of seeing legal professionals to get things organized. The interesting thing is, though, that when I ask a client what probate is, they usually cannot really answer the question. And when I ask a client what the probate fees are, which they refer to as a tax, they also usually cannot answer the question. And I find that very interesting. So for the benefit of all of us, the way I usually briefly answer it to a client is that probate is a mandatory administrative process that is put in place so that basically our executor and everything that takes place will be probed or will be audited, to provide a security system to the beneficiaries and to the deceased that things actually happened in accordance with the will and in accordance with the legislation. In terms of cost, it is a tiered system, but roughly one can refer to the fact that it will be 1.4% on the value of the estate. Generally speaking, when I mention that to my clients, they are very surprised. Most people think that probate fees are actually of a much larger percentage. So it's always interesting that these two things that they actually didn't have too much knowledge about motivated them to potentially transfer ownership, or if there's most valuable property, to other people. There are, of course, a lot of ramifications and issues with doing this, which again, a lot of clients may not have discussed. The first problem I see with that is that, of course, you do lose your financial independence. Of course, most children will be very happy to receive a property in their name or to be added to the property. However, one needs to realize that whatever the parent from that moment on wants to do with the property involves the consent and the cooperation of that child. And many people have not really looked at it from that perspective. Second component, if the child is not living with you, which is often the case, then the moment that child's name goes on title, we trigger the start point of capital gains for that child. Now, if the parent will continue to go on living for a considerable amount of years, the capital gains component will far outweigh whatever the probate fees would have been. The other thing is that once you bring someone on your asset, you invite their entire life, but also their entire finances to your life. So if that child has a marital breakdown, if they have credit issues, you could be exposed to that as well. And the list goes on, but those are just some of the main topics that should be part of the conversation when someone is debating on adding someone to the title or transferring property over to the title. Of course, if the property is completely transferred and there's not a joint component anymore, one just completely loses every power and every say. I mean, legally speaking, there are structures that could be set up with lawyers, but we're not going into the technicality of it. But generally speaking, if you're no longer a registered owner, you are no longer the beneficial owner, right? And so, you know, you've basically given up your most valued asset, not to mention your home. The other motivator for people to do this is, of course, the care component. I definitely see this a lot in my community, where people, as was discussed earlier, they really want to stay in their home as long as possible. They do not really want to go to a care home. And so that fear, that being afraid of what the future holds, you know, can definitely initiate the conversation with children or other family members. Well, you don't have to leave your home. This is what's going to happen. We will come and live, you know, on the main floor. We will rearrange the rental suite, you know, to a nice, you know, 1 or 2 bedroom apartment for you. And this is how it's going to work out. So the parent is trading off the property, or a large percentage of the property, in exchange for reassurance and the hope that they will be cared for, right? The more that the property values in the real estate market, you know, all over, you know, the lower mainland is growing, the more that people get interested to make this proposal to their parents. And so this becomes a very, this becomes a very serious issue. And again, the parent it's not that people are not intelligent, that they cannot think, that they have impaired cognitive ability. It's just the fear is their driver. And because of the fear, they are somewhat blinded and are willing to be blinded to a certain extent, you know, and are not necessarily happy that I bring up all the things that could go wrong, such as, what if your daughter becomes ill and she is not able to fulfill, you know, the care promise she's made, and you have to default to another child who now has no stake in this property? What if your daughter, you know, has a marital breakdown? What if your level of care becomes so intense that even with the best intentions, your daughter is simply not able to continue to provide for this in the long term? How do you build this in within your estate planning? And how do you build this in within, you know, the fairness towards the other children? Did you have a conversation with the other children? Or is this just something that is taking place between you and this one child? And it surprises me, but oftentimes this is exactly what is taking place. It's not a family discussion, it's a discussion between the parent and one child. So those are just the things, you know, that, you know, you basically raise all the red flags, and usually the client goes away and realizes there's a huge need for more in-depth analysis on it.
The end of 2014, we had calls from 3 men to our seniors abuse and information line. All 3 men had signed over the house to their son. All 3 men had been kicked out. 1 was at a shelter, the other 2 were staying with relatives. So things do go sideways. We had another client who was trying to get the condo back that had signed over to his son. Well, the older man had done this to avoid it being included in the divorce from his 4th wife. So he hadn't gone with clean hands to court in the first place. Also, there are cases where, as you've discussed, the best of intentions, the child will care for mum in the home until she's 95, and mum requires a higher level of care because of a stroke when she's 80, and the daughter's only been there for a few months. And the other children are saying, well, why is she getting the house when she wasn't doing the care? Often what happens at that point is lawyers get involved. They evaluate the value of the care given by the daughter. Because under Partition of Property Act, one can get a house back into an original owner's name. It's usually done through settlement rather than court. It's rare, but we're seeing it more often. So if you have an agreement with your children, make sure it talks about the what ifs and what will happen if you end up needing care more quickly or your daughter leaves or passes on herself.
Yeah, definitely. It's not about that all of these things are, don't do it or it's not possible. It's about, it takes an in-depth conversation. It takes looking at all the what-if scenarios and making sure everything is well documented. But not only that some safety nets are put in place so that the parent has a recourse and feels basically still empowered, So if things don't work out, they actually have a recourse to make it happen.
Should we go to the next slide, which is where people decide to sell their house, prices are so good, and they want to share some of the proceeds of the sale of the house with their children now. That's it. So that's sharing proceeds of the house.
Yes, it's very common that when clients come to our office and they have just sold their house and will receive, in many cases, that generation now a check from us, which is far surpassing anything they had ever thought. Oftentimes, they will say, well, look at me, I've got so much money now, who would have thought I've got 4 children, and they usually start by issuing a substantial amount of that money to their children. Of course, there is no problem with that, but oftentimes the person may underestimate what care, if care ever is needed, will cost, what their future needs may be, that once they have given the money to the children, they will never see that money back. Most children will not go to the parent once they're in need and say, thank you so much that you gave me a $500,000 check 5 years ago, which I used to pay off a mortgage or buy a second property, and now it's my turn. I will be paying for your senior care accommodations. It usually does not happen that way. I've come to believe from doing what I do that probably the most unconditional love is the love from a parent for a child. And parents, no matter what, will always continue to help children and do whatever they think they need. The relationship from a child to a parent, I've come to sort of see, is not as unconditional. And I think some parents are not so clear on that or not so sure on that. And it ties also back with what the previous speakers were talking about, which is a lot has to do with the generational aspect. If you talk to someone in their 50s versus to someone who's in their 80s, they're a different generation, they have a different view, and they have different values. We have the ethnicity, we have the religious beliefs, and also very good point that was made earlier. When people came as immigrants, many of them still go with what their culture would have done, and they expect their children to still follow through on that. But their children are second, or first generation Canadian. They're often married with someone from a different culture. And so the parent is somewhat, I would say, a bit naive or hopeful that those values that were so core to their life and how they lived their life will still be upheld by their children. Yeah, so
I had a client recently who sold her house, gave quite a bit of the money to 2 of her children, went to live with a relative in another province, didn't work out, came back home, didn't have enough money left for herself. And in fact, the 3rd child, who had a joint account with her, had taken the money out of the account. So there was very little left because that 3rd daughter claimed, well, that was going to be her inheritance anyway. Even though the mother had helped her 20 years before, after the child's divorce, to buy a house. You see some very sad situations, and human nature is pretty greedy. People often don't think they're being behaving badly. They just feel entitled and they don't want to wait. And they tend to think older people's financial needs aren't as great because they're not going traveling, they're not buying fancy cars, they're not going skiing, so why do they need the money anyway? This is very common. And at least the clients who come to us. I'm sure no one in this audience, but...
Yeah, I think also the older generation is very trusting, and also it's just, like if their banker tells them, I think you should invest your money this way, they will take the advice from the banker and will not necessarily second guess that. And the same, if their physician says, I think you should be doing this, they will do that. They won't necessarily go and get second or third opinions as the younger generation would definitely do. The difference, I think, it's just something I'm thinking about. I think that generation generally has not been confronted with lawyers or court. That's just not part of their life experience. Whereas for most of us, younger generation, we're all very comfortable, if I may use that word, with getting advice, seeking advice. We have tax people helping us. We have lawyers. People go through divorces and therefore dealt with it. And so people have been to small claims courts. We're less intimidated and less afraid of that. But the older generation, it's just not part of their realm. And therefore, they're not seeking the advice either,
Yeah, I had a call this week from a woman who provides care, had a patient, an older woman, who expressed her worry. The older woman said, I know I'm being released back home. My son has arranged for me to go see his lawyer, who's drawn up a power of attorney and documents about the title to the house. And the older woman didn't want to upset her son, didn't want to make waves, but didn't really want to go and sign this. And the care provider who called me said, well, what can we do? And I said, well, tell the woman to get independent legal advice, not to sign it, but to explain to the son's lawyer, I'd like to get independent legal advice. Whether or not the older woman has the courage to do that, I don't know. I don't know the woman.
But it would be really up to the lawyer and the notary, and that's what I expect they would be doing, to meet with the person privately in their office and making sure they have the required capacity and meet all the tests that one is to meet, but also to make sure that she's not under undue influence.
And we know very well that people often do not get independent legal advice, and we know that not all notaries and lawyers are advising that. We had one woman where she signed the documents in the back of the lawyer's car, or her son's car, and the lawyer got into the notary lawyer, I don't know, got into the back of the car with her, and English was not her first language. So, and the lawyer, I think it was a lawyer, was a friend of her son's. So, okay, loaning money to your kids.
Yes, this is something that I think has always been in practice. But I think the component that is now different is that we will see older people who, and what I mean by that, someone who's no longer economically active, engaging in lending money to their children. And again, it is, I've had situations where one of the children is in serious debt, and they have young children, and the parent feels that they want to help out, and basically in order to assist with debt consolidation of the daughter or the son, they're basically refinancing their home, which was paid off, and they're taking out a debt so that they will be paying, so that now they have peace of mind that this young family is released from all their debt pressures. People, by the time they usually come to a notary or a lawyer, they've already gone through the whole process of getting it all approved by a bank, dealing with a mortgage broker. So we usually come in at the tail end, and it can be very difficult to sort of, undo the whole process once they are at that stage. But, a parent has often, totally focused on trying to provide assistance to that child has completely lost sight of the framework in which this is happening, which is how do you make this fair towards the other children? How do you address your will? Have you changed your will to reflect this? And most people will say no, you know. The problem is, I think, that there is not enough communication between family members, and people will not discuss their issues. They will do it one-on-one, and all the others are left out. Yet the others are aware that something is going on, so they all start to create their own story of what is going on. And once that starts, then now the family is really fracturing. And by the time the parent will pass away or even is in need of care, some children will just not show up. They will just step away because they feel there was favoritism or they were not validated, right? And again, I think it's so much part of the discussion that should take place is be aware what you do will be perceived by others in a certain way. So you either discuss it and be clear, or you are willing to take, you know, the risks that come from this, right?
And we have 2 matters going to Supreme Court at the moment, fast-track litigation, trying to get money repaid to older adults. The problem is often nothing was in writing. Simply a check was given, and that was it. Even if there is something in writing, often it's not good enough. There's nothing in there about expectations around repayment. So for us to go to court with a piece of paper with maybe not even a date on it, saying, I've borrowed $15,000 from Mom, and I will repay it, signed. Well, there's no date, there's no expectations. When are you supposed to repay it? Are you supposed to repay it out of your inheritance when Mom dies? Are you supposed to be repaying it $100 a month starting now? Or when you get your tax refunds? There's absolutely no indication even to start a legal process without a date is problematic. And the child can say, oh yeah, we talked about that. When I inherit from Mom, that money will be taken into account. Well, that may be true, maybe that's a lie. People need to become a little more sensible around this. I did have a client recently, and this one ended very well, where the older woman who doesn't have much money, she gave the last of her life savings to a granddaughter as down payment on a house in the Okanagan, a small place. And it was well drawn up. My client's pretty smart. The granddaughter used the money for the down payment. Then the granddaughter, who works full-time for a utility company, went out and bought a pedigree puppy. She bought a new truck. She told her grandmother, I can't afford to repay you. And the grandmother was very worried because she didn't think she could go on renting the apartment she was in without she'd counted on that extra money coming in every month. And luckily the document said that she would be repaid, I can't remember, $300 or $500 a month till the $15,000 was paid off. And we did send a demand letter to the granddaughter. And the granddaughter's response partly had been to her granny, well, you lent money to my aunt, you lent money to my dad, why don't you get money back from them? Why are you coming after me? So in the end, it actually resolved very well. I sent a letter to the granddaughter explaining the impact this was having on the quality of life of her grandmother. And that we would be starting, it was within the small claims amount. And the granddaughter did move out of the place she'd just bought. She rented it out. She moved back in with a friend from university and was repaying her grandmother. So that girl did come through properly. Yeah. We don't see that very often.
I had a client yesterday in my office. Her son has had troubles before being a drug addict, but he was on the road of recovery and he found a job in the oil sands, and she was very excited about that. And so she agreed to buy him a truck so he could drive there, And the truck was put in his name, and but she took financing out with the local bank to do this, but with the agreement, because he couldn't get a loan for a car because he had no credit, but with the agreement that he would pay the monthly payments, you know, to her. And he did this for a while, but then of course now with the crisis in Alberta, he lost his job, with, as a result, unfortunately, that he's back down into his heroin addiction, and she actually doesn't know where he is. She can only communicate by text with him. And she now is stuck with the continued payment of this car, of which she doesn't have the ownership. She contacted the bailiff and they basically said, well, it's not your car. You know, once it's your car, call us back, basically. So, you know, and it's not just about the $32,000. It's now her husband being very upset, and they have, you know, very tense conversations on a day-to-day basis, like, I told you so, I can't believe that you did this again after everything we've had before. You know, the sister is upset because mom caved in yet again. So it's just a whole dynamic, and to see the client sitting in your office completely, you know, in despair, basically, and the shame. That's the other part that we haven't brought up. But, you know, people are ashamed, you know. Once they get to that point, they go like, how did I do this? Why did I do this, right? And I think that's why things don't always come to the surface.
And it's not only shame, but sometimes they're protective. We've had calls about the co-signing the truck loans or the car loans, and then the younger relative can't keep up the payments, and then the creditors come after the older adult who's living on a fixed income. And we had one woman who didn't want to tell them how to get in touch with her grandson because she thought she was protecting him. He had actually smashed the truck by this point. And we had to say, well, if you want them off your back, he's going to have to step up here as well. So co-signing loans, co-signing mortgages, parents co-signing children's mortgages, children co-signing parents' mortgages. And there is often pressure to co-sign loans. They try and guilt the older adult out.
And we also see the reverse. So we were just touching base on parents helping children with, you know, and therefore taking a loan on the parent's house. But we also have the opposite, that the parent needs money because they need to do renos to the house or whatever it is, and they no longer qualify by the regular banks. So in order to get the loan, one of the children will basically co-sign and step up, right? But the problem with that is, of course, that it affects the estate planning, and it affects what is going to happen in the event that something happens to that child. You know, if they pass away and they cannot make the payments, where does that leave the repayment? So it's very interesting. We definitely in our office see a rise of reversed mortgages, and we see a rise of private lending. And it's because we all live longer, and people go into retirement with debt, and they are usually not prepared for the fact that the financial institutions are suddenly no longer interested in you because you don't have the cash flow. You may have the equity in the home, but you don't have the cash flow. And so again, it's an area that is definitely inviting abuse is a strong word, but all kinds of sort of twisted dynamics.
Our legal advocate, half of her work is around helping people get benefits. A lot of her work is also helping tenants, aging tenants. And a growing amount of her work is helping people with debt, seniors with debt. And the Credit Counselling Society of BC, which is a non-profit that helps people deal with their debt issues, said the number of clients who are seniors used to be infinitesimal, and it's growing every year hugely because people are retiring with debt. And I don't think pension plans are what they once were. Credit cards. I was just listening to a webinar out of the States where they're trying to develop a tool to make judgments about capacity of older adults for financial decision making. And they were saying in the States that debt, one of the biggest problems with debt is credit card debt of older adults, because it's easy to get a credit card. It's tempting to use them for yourself or to give cards to your kids or grandkids. And certainly, one problem is giving somebody else your credit card to use, where you have no control how they're using it. And with the 2 cases that we have going to court to get money back for our clients from their children, both involve the use of credit cards. And for some of the purchases, it's actually really good for tracking where the money was spent. So if it was spent at a bar or a pub or the gas station, buying building supplies, it helps us to show that Mrs. X at 85 wasn't out at the bar and she wasn't buying the building supplies and stuff. But credit cards are widely shared, I think, by people with their relatives. And it's also sometimes there's pressure put on older adults to get a credit card because the older adult may have a good credit rating for a relative. And it's really not a wise thing to do. Getting smaller credit card limit on shared cards. Many older adults where a relative or someone else is a caregiver and who needs to go and do the grocery shopping and other shopping for the older adult. The older adult should take out a new lower limit credit card. Sometimes that's a problem because often the credit card companies won't give you a low limit. I do know of people who've tried to say, well, I only want a limit of $1,000. And they'll say, no, we can't give you less than 10,000. We had a client who was quite cute. She lived with her daughter and son-in-law, and they went off on vacation. And while they were away, the woman's mother, using a very high-limit credit card, bought a hot tub and had it installed in the back garden. And when the daughter and son-in-law came home, they found a hot tub off their back deck, which hadn't been there 2 weeks or 3 weeks before. And the hot tub company actually was very good. They did take it back. But the client, the older woman's daughter, was furious that the hot tub company had gone ahead and done this when it should have been obvious that their mother didn't know what she was doing. Well, I met the mother, and she presented extremely well. She was charming. And as I said to the daughter, well, if you have concerns of your mother's financial decision-making, why does she still have a credit card with this limit? You can't, and it was the mother who had called the hot tub company because she'd seen the flyer through the door and wanted the company and had invited them into her house to discuss it. So often, who do you blame? Autonomy versus risk. Yeah. Did you have anything about credit cards with your clients? Or?
No, I don't necessarily get involved as much with that aspect of credit cards in my practice.
So our next slide, this is good. Joint accounts and bank powers of attorney and other powers of attorney. Okay.
Yes, I have a big issue with this. And it leads to so many long problems. Here's the thing. First of all, a lot of people are not aware that when you make an asset joint, typically a bank account, unless it's specifically stated differently, but generally speaking, this means that what is mine is yours and what is yours is mine. That's what joint generally means. This also means that it creates a right of survivorship, right? So when I see a lot of situations with elderly clients.
Actually, it doesn't automatically create. This is a huge misunderstanding.
Not automatically.
The Supreme Court of Canada has said that if it's a large account and the older person dies, the daughter or son on the account isn't necessarily entitled to scoop the lot that may become part of the older adult's estate, which now has to be dispersed according to the older adult's will. So if they have a few $100,000, it may have to be divvied up between the 3 kids. I was at a Canadian Bar Association meeting in Ottawa last year, and there's lawyers from every province. And the lawyer from PEI said, well, I think it's a rule of thumb for the banks there. If it's over $50,000, they don't let the kid take it. And if it's under that, they don't bother about it. It's a very gray area when it becomes part of an estate as a right of survivorship. But many forms, you just tick saying right of survivorship. Whoever's on the account with me scoops the lot. That may not be the intention of the older adult. She's just wanting this relative to help her with her finances, not necessarily get all the life savings bypassing the will. And I'm sure you've heard of situations where that's happened as well.
Yeah, it happens actually a lot, and I think it's often in real life presented as a practical alternative or solution towards a power of attorney. It's like, well, your daughter is helping you with your bill payments anyway, so why don't we just add her to the bank account, right? And that is where the first problem usually starts, right? Not just the whole discussion about yes or no right of survivorship and what will happen, but also that the illusion may be created to the person that now there is no longer a need for a power of attorney, or all of a sudden all the problems are fixed, right? The power of attorney is a very, very, very important document, not just because it's very powerful, but in my opinion, mainly because there is no default system in place. The law does not assume because you've been married for 50 years or you have an excellent relationship with your child that if you are in need of having someone help you with your finances or take over with managing your finances, that your spouse of the past 50 years is the person who can do it. If you have not made a document, then the only recourse is to do an application for committeeship. So I think, you know, having a power of attorney is extremely important, and it's a discussion that should take place, and people should be encouraged, even when they talk to their banker, to do this, and be made aware that even when they sign the power of attorney document from the bank, that is not allowing them to address any and all matters outside of the bank.
It's very difficult. I mean, the bank is not the parent of the parent. We cannot expect the banks to monitor every activity within a person's account to ensure that nobody's taking advantage of anyone else. We can't expect them to do that. There's a bank in the United States in Fork, which apparently is the name of a place in Utah, and they have developed specific accounts and monitoring devices for older adults' account, if the older adult asks that these put in place. And the woman who worked on that is now in Washington. So in Canada, we've been following developments there. We did have someone speaking from the Fork Bank in Utah who said they're more like a credit union. It's quite easy for them to put monitoring in place with a small number of members, whereas for the Royal Bank or the TD Bank or Scotia, it's pretty impossible, well, to expect it to be monitored on that scale. However, there was a case we got involved in because one of the daughters phoned us, and the public guardian trustee had already been involved in this case. It was in northern BC, where a woman who was losing her capacity gave power of attorney to one child who lived in the community. The others all lived elsewhere. And that child took her along to the local bank, had a mortgage taken out on the mother's house. The money went into the joint account. He took the money out of the joint account. The money was all gone by the time the sisters realized what had happened. Whether and the woman did have dementia. She actually went into a home and luckily had 2 pensions through her deceased husband, so she was pretty well taken care of and didn't know what was going on after a certain point, so it wasn't too upsetting for her. Should there have been some liability on the part of the person who met with the son and mother to talk about taking out a mortgage on a house that had never had a mortgage on it, and money scooped entirely out of a joint account? Who can have oversight of everything? It's a growing problem. Should the daughters have been involved? Who's to say? They'd never have thought their brother would have done this, what he did. So, and there's no easy answers as far as I can see. At the moment, if you have weird transactions in your credit card, you'll get a call from the credit card company saying, by the way, are you in Mexico? Your card's just been used. And you say, no, I'm in New Westminster. You won't be out of pocket for that. If there is a loss, it goes with the credit card company. But if there's a big withdrawal from your account, you're not going to get contacted. It could be done if there was will to do it, that older adults could say, if there's a withdrawal of more than 5,000, can a red flag go up and can someone contact me? Or maybe by then the older adult doesn't have capacity to know what's going on in their accounts anyway. So I don't know the answers. Getting print out of a statement sent to the older adult so one of the other kids can see it is one idea. Not letting everybody use your ATM card. If you have a caregiver, get a smaller account set up with an ATM card just attached to that small account, not one that can be used for your entire life savings. Another thing we find with joint accounts, I had a client who just decided not to go ahead to court to try to get the money back that had been, her mother's accounts had been completely drained within the year that after she lost her husband when she was living with the son. And when the older woman went back to the daughter, who I'd been dealing with, we were looking at going to court to try and get money back. But it turns out that the daughter, the mother's now living with the daughter, has a joint account now with her mother. And the daughter just automatically takes out money from the mother's account, the mother's pension, every month without any receipts, without tracking what the money's on. She says to me, oh yeah, well, we use it if she needs clothes or pedicures or for treats. Well, if she's taking 50% of her mother's pension every month and thinking this is fine to do, maybe it is, but I advised her, you'd better keep records because you're doing exactly what your brother did when your mother was living there. Except you're not taking 100% every month, so you're not feeling, I didn't say it in these words to her, so you're not feeling as bad about it, but basically what you're doing isn't very different from what he was doing. And that's why joint accounts can make it very easy. Oh, we had a power of attorney that you were going to talk about, is you draft lots of these.
Yes, so powers of attorney, usually when we refer to this, we refer to the enduring power of attorney, which basically means that it's valid while a person is capable, but also obviously in the event they ever were to become incapacitated. I'm just saying that because often people are not quite sure about the enduring aspect. Even though after the change in the legislation, someone can now make a power of attorney themselves, and the document is available on the website from the Attorney General, I would really encourage everybody to go and get that done through a legal professional, just for the reason that first of all, most financial institutions will not feel comfortable dealing with a personally drafted power of attorney for all the reasons everybody's been discussing at this conference. Most banks actually have their own protocols in place which are very strict. And so when I in my practice make powers of attorney for clients, particularly if my clients are a bit older, I recommend them that they make an appointment with their branch representative and actually go and discuss with them and show the document that was just made. This way, the bank already knows, they see the client while they're very cognitive and can have a discussion about it. They put it on file, and usually there's less issues when then the attorney has to start acting. I find that when an attorney has to start acting and the banks and so on are not aware of the existence of the power of attorney, the documents get sent to head office in Toronto. It takes them a week before it comes back, and the client often feels, that they're up against a wall of frustration. We have 4 minutes. It's important, as Mr. McClellan was saying, with regards to representation agreements, it's a bit the same things that apply to the power of attorney. I actually look at them as 2 documents that hinge on one another. One is dealing with healthcare and personal well-being, and the other one with your business affairs, if I may put it this way. But in both, you're basically doing an unconditional vote of trust, where you appoint someone and say, I know that this person will always act in my best interest and do what I would have liked to see happening. Therefore, you need to have a discussion as to who that should be or whom that should be. If there's more than one person, do you place them in an order, or do you place them on an equal basis? Under the change in the last legislation, you can now make a lot of provisions whether or not the person should be compensated for doing this, whether or not the person has access to your safety deposit box, whether they have access to know your will. This can be important if there ever was a sale of the family home while the person is incapacitated. Does the power of attorney have the ability to disperse some of the funds? You can only do that if you know what the power of attorney says specifically in that regard and what the will says.
And the biggest problem growing that we're seeing is people who have nobody to act as as attorney, nobody to make their healthcare decisions. They have no spouse, they have no children, they don't have any relatives, no close friends. They're loner type people, and it's really very concerning. We've got 1 slide left and not enough minutes, but the next is basically remember to review your planning documents and keep them updated. And again, we've referred to the NIDIS registry. And the last, sorry to rush you, but we're sort of out of time. And the last slide, the Canadian Bankers Association, Your Money Seniors, has a lot of really good information for people to protect their finances. I do recommend it. Our website, and we have a toll-free phone number for any questions. Half the calls are not from the older adult, they're from concerned friends or professionals. And we have a free book on our line called When I'm 64 Benefits. Make sure you're getting full benefits you're entitled to. Most people are not. And another book, When I'm 64 Services. Many people don't know about services available to them. And another book just came out, Legal Issues in Residential Care, to help you resolve in a timely manner. And Al Gina, who's here from BC Care Providers and the Health Authority, PGT, all had input into this. And yeah, thank you. We did it.